Last episode, we exposed how courts invented levels of scrutiny, the measuring stick for how much freedom you're allowed. But where did the government find the courage to use those tests in the first place? They found a shield, a magic phrase that excuses anything: public interest. The two words that built an empire of control. Every abuse of power you've ever seen, censorship, lockdown, surveillance, property seizures, all of it hides behind that slogan. The founders called for limited government. The judges gave us unlimited justification. This is Constitutional Outlaw. Episode 3, Balancing Liberty Away, the rise of the public interest excuse. The birth of a doctrine. The Constitution was written to restrain government, not to empower it. Its purpose was to secure liberty, not to balance it against needs of the state. But when courts crowned themselves final arbiters, they needed logic to defend their decisions. They couldn't openly say, "We overrule freedom." So they said, "We balance freedom." The words first appeared in the 1800s under the idea of police power. States claimed the authority to regulate for health, safety, and morals. At first, it was narrow: quarantine for disease, fire code for safety. Then the phrase mutated. Suddenly, police power justified every intrusion from zoning to censorship. Judges called it reasonable regulation. And public interest became the courtroom password for government intrusion, the new religion of collective good. By the 20th century, the phrase public interest had become the secular gospel of control. Politicians used it to pass laws. Judges used it to bless them. And bureaucrats use it to enforce them. Public interest is never defined in law because definition is limitation. And the government doesn't like limits. When you ask what it means, they answer, whatever protects the general welfare. But who decides what that is? The same system that benefits from your compliance. This is how the Constitution was inverted. Originally, rights were absolute until the people delegated specific powers. Now, powers are absolute until the citizen can convince a judge otherwise. They called it balance. We call it betrayal. From balance to bludgeon. Once the balancing test was born, judges applied it everywhere. They decided that liberty is just one variable in an equation. Government claims safety. You claim freedom. And they get to choose which side wins. That's not law, that's gambling. And in this casino, the house always wins. Cases like Jacobson v. Massachusetts, 1905, set the tone. The court upheld forced vaccination under public health necessity. The ruling said personal liberty may be subordinate to the common good. That phrase, subordinate to the common good, is echoed through every modern violation of rights. It was quoted to justify internment in Korematsu, censorship in wartime, and lockdowns a century later. Every generation recycles it, paints it patriotic, and calls it progress. But the founding generation didn't fight a revolution to balance liberty. They fought to secure it. The public interest as weapon. Here's the dirty secret. Public interest is not law. It's a spell. Say it in court and rights evaporate. You want to protest? They say, not now, public safety. You want to speak freely? Not that misinformation. You want to defend yourself? Not their public order. You want privacy? Not any more security. The Constitution was written to restrain all of those excuses. Yet judges recite them like scripture. Because when a government can define its own interests as compelling, you are no longer a citizen. You are property. The trap of consent. The system works because you still believe you have rights. You do on paper. But every one of them now requires permission slips called tests. When you're forced to invoke your rights, to ask for them, explain them, justify them, you've already surrendered them. That's what balancing does. It converts liberty into negotiation. And that's how we got here. A country where you can be arrested for defending yourself, silenced for speaking truth, and tracked for walking free. All in the name of public interest. The American contradiction. The Declaration of Independence says governments derive their just powers from the consent of the governed. But consent is meaningless if it's coerced by fear. The framers never wrote, except in emergencies. They never wrote, unless experts disagree. They never wrote, so long as it's reasonable. The Bill of Rights doesn't contain an asterisk. Freedom is not a variable. But to the modern judiciary, it's a dial, one they can turn down when the public is scared enough to let them. Every crisis creates new precedents, and those precedents never die. They linger, ready for the next public interest emergency, the cost in blood and silence. Ask yourself, when did public interest ever give rights back? Never, because fear is profitable and liberty is expensive. They tell you it's for safety, but there's no safety in servitude. A safe citizen is a silent one. The founders pledged our lives, our fortunes, and our sacred honor. Today's leaders pledge reasonable regulation. That's not evolution. That's extinction. The people's reckoning. So here's the line. If the state can redefine your freedom whenever it wants, then freedom doesn't exist. If you can lose your rights in the name of public interest, you never had them. And that's why this movement exists, to remind America that we the people are the public. Government doesn't have an interest apart from ours. When it claims one, it's acting for itself. Knowing your rights isn't optional, it's survival. Because if you don't know your rights, you don't have any. It's time to stop begging the courts for justice and start demanding accountability from those who swore an oath to uphold it. This is Constitutional Outlaw, the people's courtroom against overreach. Because justice doesn't plead bargain, and neither should you.